Hello everyone, and welcome to the witness list section page under the Module 5 of the ULV Justice Center website. Before we begin, please know that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult an attorney. Today we'll be discussing what is a witness list, where are you in the process, what is the purpose of this step, what do I need to accomplish during this step, what is the timeline, and what is expected to happen next. What is a witness list? Witness list is a list of people you intend to call during your trial or hearing. By filing a witness list, you are telling the court and the other party who your witnesses are that you will be using at trial. Where are you in the process? At this phase, you have completed all discovery motion, designation of expert, and have attempted to settle your case a couple of times. The next step is for you to lay out and organize your witnesses and exhibits. This is accomplished through preparation of a witness list and exhibit list. After preparing your witness list and exhibit list, the next step in the process is creating a trial brief. A trial brief sets forth the facts, evidence, and legal arguments that you intend to present at trial. How many types of witnesses are there? There are 3 types of witnesses. The first witness will be a lay witness. A lay witness is a witness that brings observational testimony to the proceeding after having seen the alleged incident. The second will be a character witness. A character witness is a witness who vouches under oath to the good reputation of another person, often in the community where the person lives. These witnesses usually don't see the incident take place. They can be very helpful in a case because they know the personality of the defendant. The third will be an expert witness. An expert witness is a witness who allegedly has specialized knowledge relevant to the matter of interest, which knowledge ostensibly helps to make sense of other testimony, documentary evidence, or physical evidence. What is the purpose of this step? The purpose of this step is to make sure you'll be able to present all of the evidence you have gathered through your investigation and discovery. Every piece of evidence will require a witness that has personal knowledge of the evidence you want the court to consider. Personal knowledge means the witness saw, heard, smelled, tasted, or felt the evidence themselves. If evidence does not have a witness with personal knowledge to testify to what it is, then evidence cannot come in. After you lay out and organize your witnesses, you will complete a witness list. The witness list provides a fast reference to the identity of each witness, what evidence you hope to get from them, and how much time you need for their testimony. What do I need to accomplish during this step? If you need help creating a witness list, please note that there is a template provided at the bottom of the page to serve as an example of what a witness list should look like. Before creating your list, there are a couple of things you should gather. The information you should gather are as follows: name, addresses, and phone numbers of all witnesses you plan to use during your trial. The dates each witness is available or not available to testify. The manner in which you have secured the witness, which could be through subpoena, notice to appear, or voluntary agreement, the order in which you plan to call each witness, and the evidence to which each witness will be testifying and cross-reference questions. What information should be included in the witness list for each witness? Once you've gathered the information you need, you will then create your list. The information that should be included in your list is as follows. Number 1, witness name and address. 2, summary of witness testimony. And 3, time estimate of the witness's testimony. Who do I send the list to? You should have 4 copies of your witness list. 1 goes to the opposing counsel, 1 to the judge, 1 for the court clerk, and 1 for you. When and how do I send and/or file this? The judge will set time limits in your case, and will indicate when your trial documents must be exchanged. Make sure you exchange your documents in the time that the court requires. You would file and serve the witness list as you would any other document that needs to be filed and served. What is the timeline and what is expected to happen next? Once you have filed your witness list and exhibit list before trial, you will meet with the opposing counsel and discuss objections to the exhibits and in limine motions. If objections to the exhibits are unresolved, then they will be handled by the court during the pre-trial conference. A pre-trial conference is a meeting of both parties to an action and their attorneys held before the court prior to the start of trial to address issues related to the trial, including motions in limine, time estimates, evidence issues, witness availability, etc. This has been an overview of the witness list. On behalf of the ULV Center, we thank you for your time and hope this information is helpful in your legal matters.